Hello and welcome to Working with Foreign Counsel, Ethical and Strategic Considerations, hosted by Virtual Patent Gateway and moderated by Judy Chung. Virtual Patent Gateway founder Ashley Chung has a passion for supporting the next generation in the workplace and is committed to developing a growth mindset within VPG. Today's panel consists of York Moody Faulkner, a veteran trial lawyer with more than 30 years of experience and founder of the YMF law firm in Tokyo, Japan. Melanie Grover, a partner at Brakes Hughes Bellarmine LLP in Ashburn, Virginia, who focuses on strategic patent prosecution and client counseling. Nancy Song, a Chinese patent attorney at Linda Liu and Partners in Beijing, China, and Elisa Youngson, an attorney at Mere Patent Law in Great Falls, Virginia, who focuses on prosecution of U.S. and international patent applications. Today's moderator, Judy Chung, is the Senior Patent Counsel Packaging at the Colgate-Palmolive Company, and her practice focuses on strategic patent procurement, global patent prosecution, client counseling, freedom to operate opinions, and competitive landscaping analysis. This webinar will be recorded for future use, and we've applied for 1 hour Virginia CLE. Ashley will notify you when it is approved. And with that, I'll hand things over to Judy.
Thank you, Caitlin. Good morning, everyone, and thank you for joining today. And before we get started, I must say, the view that I'm about to express today will be my own only, and it's not on behalf of Colgate-Palmolive. So I'd like to welcome everyone to this wonderful segment that we have for you guys, working with foreign counsel, both ethical and strategic consideration that comes with it. And there is a lot that we have on this agenda, and we actually prepared quite extensive slides that will be uploaded and shared with all of the participants today. And because there's so much, we may not be able to get through all of the slides, but you will have a chance to review it in much more details after today's webinar. So with that, Caitlin, let's go to the next slide, agenda. Perfect. So there's basically 4 topics that we wanted to discuss today. Number 1, in working with foreign counsel, so there's certain language and cultural barriers that we want to discuss. And then, of course, dealing with foreign counsel, we got to deal with professional translations when it comes to patent prosecution or even litigation. And then the third topic we're going to be talking about is how do we keep the client informed? And more importantly, who's the client? And then the 4th topic, which is a little bit more US-centric, we'll examine the attorney-client privilege concern that comes with us working with foreign outside counsel. So next slide, please. And here's just the panel, so you can skip. Next slide. Perfect. So the first topic we're going to examine today with the panelists is the language and the cultural barriers when we work with foreign outside counsel. And now the first question that came to my head when we were talking about this topic is, why do we care? Why is this even relevant? So next slide. And that's because there's a model rule that governs our practice, and lawyers should provide competent representation. So it's very important that we represent the client, that we at least can engage in that communication, two-way communication, right? That's understandable from both sides. And then we see that there's something that happens during this interaction if we don't take cultural and language barrier into consideration. So with that, I would like to open up to the panelists. What are some of the things that you see that you encounter when dealing with foreign outside counsel? So I'll open this up to Elisa first. If you want to talk about from the US perspective, when you engage foreign counsel, what are some of the things that you've encountered?
I think the first thing is really being sensitive, and I know Nancy has some good insight on this as well, but being very sensitive to words that don't translate out the same, that, you know, especially when it comes to instructions and things. You know, that's kind of the incoming aspect. The outgoing aspect is the care that needs to be taken when you kind of take, for example, in patent prosecution, if you get an examiner's action and you need to explain to the client what happens, just being very sensitive that sometimes things don't translate the same one really big example that I run into frequently is terminology like the broadest reasonable interpretation, that, you know, the examiner may interpret something a certain way. It's not going to be the first definition of that word. It's not the obvious definition, but I need to be very cognizant of that and communicate that to the client. And, you know, so it's both a language issue and a legal issue. So that's kind of the first couple things that come to mind.
Okay, and since you pointed out Nancy, would you like to comment?
Yeah, sure. Just to add on, at least, I think there are legal hurdles, just like the broadest reasonable interpretation. It could be broader than for us, the Chinese practitioners may think of. And in addition to the legal hurdle, there are also cultural hurdles. For instance, I'm from China, and usually the Asian culture, people are more, you know, we speak in a more tender or soft way. We are not as direct as you know, the Western practitioners very often. And I clearly remember one time there is a case from the Chinese applicant. So it's a US inbound case. And the applicant actually already decided on their response strategy they would like to go on with. But in their instructions sent to the US outside counsel, they said, you may consider blah, blah, amend this, blah, blah, and argue like this. You may consider. And I think the US outside counsel did consider to proceed in that way, but they didn't believe it could be very effective. So they actually substantially changed the proposed way from the applicant. And then the applicant came back to us, and my colleague, actually in the chemistry field, they came back to me, and they were really anxious and confused. They asked me, so why didn't the US counsel follow our response instructions? We already asked them to amend in this way and argue in this way. Well, from my perspective, I could understand that because we use the terminology like, you may consider, and the US counsel did consider this. Well, the actual purpose is that it is my intention. This is my instructions. I carefully considered and requested you to do this. So this could be a really different point of view. So when you're working with Chinese client, maybe this is a point noteworthy.
Right. And what about Melanie? Have you encountered anything similar where an instruction, because it came in softly, became a suggestion and that you didn't really implement?
Yeah, I think I'm almost on the other side of that, where I have communicated with foreign counsel and said, you know, you may want to consider this. And I really meant it as, you know, hey, this is just a suggestion, you know, if you think it would be better to do it a different way because of the local jurisdiction rules, or, you know, the way that things, that your local practice is, that, you know, I'd like to know if you think that that would not be the right way to proceed. And so knowing those cultural differences, I have changed the way that I present instructions or, you know, advice when I am working with local counsel to provide a response, you know, for a US client. And I can see that same way, if the client is a foreign client, you know, if I'm actually kind of saying this is what I think should happen, but I'd really like to know what your opinion is, as opposed to like, this is what I want, this is what you should do. So I think that that awareness is really good going both ways.
Okay. Then what about your practice in Japan then, York? Have you seen anything like this? Well, I can imagine, especially when it comes to Japanese language, it's probably more so than just, you know, in addition to the cultural difference, and then even just the choice of words could probably be a problem.
It is interesting. Japanese is a unique language. It's perfectly acceptable to have sentences that have no subjects. Grammatically, it's perfectly fine as long as everybody understands what you're talking about. The problem is everybody doesn't always know what you're talking about, and there's often points of confusion. But in terms of cultural issues, the one area that I see a lot of tension between Japanese counsel and US client is in the drafting of briefs in Japan for submission to the IP High Court or the district court in Japan. Legal writing in Japan is a very different thing than legal writing in the United States. Japan has a very Japanese lawyers have a very structured way of writing. It fits with the way that courts write legal opinions. They define terms up front, and then they use the defined terms throughout, and it's very structured, and it's sometimes very difficult to follow for the US reader, even in translation. And so when clients see that, they generally want to rewrite the brief and make it follow more of a US type of briefing and writing. And there's often tension between the client and the lawyer in that point. And it's been interesting. One of the roles that I've had is trying to bridge that gap a little bit to push the Japanese lawyers a little more to the US style of drafting, while at the same time helping the client understand that things are done a little bit differently in Japan. So there are some challenges with the language and just the approach to legal writing.
So given that awareness that you have you incorporated that into your practice in terms of before the client even seen the brief, do you then preface it by saying, by the way, it's going to come to you in a certain format. Don't be alarmed. That's just the way, do you tell your client to just focus on the content and don't worry about the formatting? Or how do you go about addressing that to make sure, you don't have this first round of back and forth just simply over the formatting?
Mm.
A little bit of both, actually, to let them know that the format that they will see may be a little bit different, but that, and I usually have the same discussion with the Japanese lawyers, that you may get comments from the US client, because usually the US client, they may be outside counsel for the client, but usually they're in-house counsel. We're very adept at litigation, and they know what they want. And they want to see it reflected in the briefs that's being submitted to the courts in Japan. So it takes a little bit of preparation on both sides. And I find that Japanese counsel kind of enjoy the process. They get pushed, and the comments at the end, they kind of appreciate seeing a different perspective and way of writing. And they've commented that some of them it's changed their practice. And it's been a very interesting thing to watch.
Okay, well, thank you very much. So let's see if we can move to the next topic. Ken, would you want to advance the slide a little bit? So the next couple of slides talks about, really it just lays out the rules under the model rules. That 1.4 talks about how the lawyer should represent the client. So next slide. And then we have a few, I'm sorry, did I hear a question? Oh, sorry. And then the next two slides, we have prepared a few of the ethic opinions on competence, whether or not a certain attorney's behavior met this bar and in representing their client. So you guys can take a look after the webinar. The next slide, please. And then here's a couple more from New Hampshire, from New York, and from Utah. Basically, if the attorney cannot communicate fluently with the client and you don't understand what your client wishes for, then there's a question of whether or not you can represent your client competently. So next slide, please. So the bottom line really is just summarizing all the previous slides, that it's the lawyer's obligation to ensure. Yeah.
So just one comment really quickly. The second bullet, that kind of goes, in my view, it goes to what Nancy and I were saying, that in order to ensure adequate communication with the client, I think those cultural differences definitely need to be top of mind, so that, if the client is saying, you may want to do this, being aware of those cultural differences helps you better fulfill this obligation to ensure the adequate communication, that you understand that they're asking you to do that, not just think about it.
Right. Well, thank you for pointing that out. And I think I experienced that when I first joined Colgate, but I think eventually you realize, right, the law firm that you work with, that's just the way they present their email, and that you understand when they say may or you should, it's really you must, you shall. So I think that also comes with, perhaps a longer term relationship, then you'll understand that there are certain words, certain keywords. And that, I see Nancy smiling. So now if you see it from the same client, you know what they meant.
Yeah, sure.
Judy, I'd just like to kind of really emphasize that when you look through the ethics opinions, that there's a very clear correlation between competence and communication, that you cannot provide a client competent representation if you aren't able to adequately communicate with them, to communicate out to them, and then to understand what they are saying to you. It's a two-way street. It's not just, us telling them, it's, hearing what they have to say. And that includes the cultural issues, understanding that they may not present the information in the way, a more direct manner, but you have to be sensitive to the fact to how they present it to you. So very important to remember. And at the end of the day, it's the lawyer's affirmative obligation. It's not the client's responsibility. It's the lawyer that has the responsibility of recognizing any shortcomings and then addressing them here.
Right.
I'll just add one thing real quickly. In addition just to the language issues, in terms of litigation in the United States, it's very different than in many places in the world. Japan is an example. They just don't understand US discovery, jury trials. Generally, new clients who are being introduced to US litigation for the first time requires backing up and explaining just general concepts about US litigation, just to get everybody on the same page before you even get into the specifics of the case. If you try jumping in too quickly to the specifics, they have no context and they just have a hard time following.
Mm-hmm.
Good point.
Mm-hmm. And another point here is to be accessible to your client, or to be accessible to your foreign associate. I also remember one time we had a really urgent case. We received the filing instructions in China just 1 week before the legal deadline. And the US attorney was very confident that he would be able to send us the Chinese translation on the last day, on the exact day of the filing deadline. And we said, okay, despite our multiple reminders. And on the exact day of the deadline, he still believed and said, oh, I will send you the Chinese translation really soon. And there are about 4 hours left. So already 8 o'clock in the evening, Beijing time, we still received nothing. And all the email communications provided by the US attorney and the third-party translator, they only have the office telephone number. And of course, because of the time difference, we were not able to reach them at their office. And there is no, not any personal like mobile communication, mobile numbers. So we had to wait really anxiously until the last minute. We actually received the Chinese translation at about 11 p.m. and we managed to finish all the check through multiple persons inside the firm, and finally filed the Chinese translation of that application 5 minutes before the deadline, 11:55. That was really a very dangerous, or we didn't expect that to happen again, and I think no attorneys would like to see that. And later on, we actually talked with that US attorney. So how did that happen? If we see it must be an urgent one, only in 1 week. So if the third-party translator can provide us with their mobile phone number, we're able to reach them at least, and to ask them and to check at what minute could you provide us with the translation so that we could be prepared in the docketing department, etc.
Right.
And the US attorney said he was not actually aware that China has the special requirement that the Chinese translation must be provided at the deadline, by the deadline. And of course, we know in many other jurisdictions, you have a foreign language filing system, but in China, we are unique. We are required to file the Chinese translation on the same day. And actually in our first email acknowledgement to the client's instructions, we stated in the first sentence that Chinese language must be filed simultaneously by the deadline. But because the attorney was totally not aware of this difference, I think he simply overlooked this first sentence in the email. Mm-hmm. And he didn't know how urgent this case could be. So I think keep in mind the differences between different filing particulars in different jurisdictions. And a 7-day case is already very urgent. So be accessible, probably provide your mobile phone number to your associate could be a guarantee to the client service quality.
Well, that's a great point. And there's something you mentioned as well to note the time difference, which thank you and York for making time, because I know it's quite late in Asia. But as you just pointed out, even if it's the last day, right? If it's already the last day in the US, it could be the next state already in Asia. So we definitely have to be more mindful when communicating, especially with overseas, drastic time difference. So that's a very good discussion. Next slide, please. So I think this slides just touch upon all of the discussion that we have surrounding this, difference in culture and language barrier issue when we deal with the foreign counsel, right? Be mindful of the cultural and the language differences, and understand that especially certain legal terminology does not translate. And like you pointed out, there's certain practice that doesn't even exist overseas. So there would be no discovery and things of that to consider. And then yesterday we were talking about what was it? Conflict of interest, right? That's a very, very important topic for the U.S. practitioner. But when it comes to a foreign jurisdiction, maybe not so much. We've had cases where our foreign counsel handles both for Colgate, their prosecution overseas, but also one of our major competitors. And when you approach the foreign counsel, they have no concern, because that's just the conflict of interest just doesn't work the same for them. So they've never raised the issue. And when we raise it to them, they simply came back and said that's a non-issue for them. So this is something that we should keep in mind as well, that I believe most of us are US practitioners on the line. So when we approach a case, we're definitely more US focused and US centric, but there are certain things that just simply does not apply. So we have to keep in mind of all that as well. Next slide, please. So next we have, wow, this flows right into what Nancy was just talking about, the translations. So another important piece of us dealing with foreign outside counsel is the professional translations, right? When you want to, especially when it comes to patent application filing for prosecution, a lot of times you may need professional translation of your application. So especially for China, if you want to file a Chinese patent application, you have to file the translation with it. Next slide, please. So this first slide for this section is basically shows the model rule 5.3 is a lawyer's responsibility, really. So it's on the practitioner that when you seek a non-lawyer's assistance, it is still your responsibility to make sure they provide whatever it is that you ask them to do. So you cannot just simply send out, let's say, a project and just leave it. It's really up to you as the attorney to make sure, in this case of a translation, that the translation is done properly, competently, and that there's no error. So next slide, please. And there are certain circumstances, right? There are certain times where a professional translation is not needed. So the first point is more applicable to me as an in-house attorney. We see a lot of translation internal documents that come through my way. For the most part, I do not need a professional translation. I can just use Google Translate, because all I need to understand the gist of it, right? If I'm not filing those documents, it doesn't have to be professionally translated. And also, because we're in-house, we're more cost conscious. So if you don't have to spend money, you won't do it. But obviously, when it comes to patent applications or any contract that's going out, you may need professional translation. So besides the timing that we were talking about with Nancy earlier, what are some of the other issues when it comes to, getting a professional translation done? Who wants to take this on first?
I think the next slide, I think probably because York can probably speak to the next slide. It's a good example.
Oh, yeah. We have 2 or 3 examples that are kind of interesting. The top example, the characters mean Torokuhi. It was actually translated in the document as sign up date, which is a literal translation. But in context, it was obvious that it really meant the patent issuance date. And I think this was a professional translation. It was an agency that did the translation. And I think it ended up in the hands of a translator who just didn't have a lot of patent experience. I think probably a very competent, good translator, but if they don't have experience in the field, it's easy to make these kinds of mistakes. In Japanese, and I assume it probably happens in other languages too, that there's a phonetic alphabet, and this word is kuromachin. And the translator made a guess. It's a biotech case, and translated as chromosome, but it really is chromatin, and they're structurally closely related, but they're 2 very different things. And in this particular matter, the difference between the 2 was very important. So it was a difficult mistake, but it was good to catch. And I think there's one more example on the next slide.
So before we go on the next slide, who caught it, York? Who caught it? Was it before filing or was it after?
Oh, it was before. It was before. And it was just a matter of just kind of reading through and checking things. And it was an easy catch because the translation was from Japanese into English, and the English didn't make any sense. So when you see that, you go back to the Japanese and you realize, well, that you can find the mistakes usually pretty quickly.
Okay, so it was in the review of the translation, that's when you caught the.
Right.
Got it. Okay, and then you have one more example.
Oh yeah, so this is a patent claim, and the word quench needed to be translated. And there are 3 different options. One is to quench your thirst, one is shoka, to extinguish, and the other is reikyaku, to cool off. And you're reading through the claim real quickly, you see that it's talking about injecting water into a chamber where there's gas and ignition. And I think what the translator did in translating this into Japanese, saw the word gas and ignition and just assumed that the water was being used to put the fire out. And so chose shokyaku as the word to use. But that was the wrong word, because if you read down to the claim a little bit long, toward the bottom, you see that the intention of quenching and the injection of the water was to cool the gas in the chamber. The gas was a byproduct of a prior ignition that had already happened. And so the correct translation is reikyaku. And so this, I think, was unfortunately not caught and ended up in the claim. And when that happens, sometimes you just have to live with it. And it can cause problems down the road.
Actually, that was going to be my follow-up question. In cases where there's a clear translation error because, whoever translated it picked one of the 3, is there a mechanism outside the US where you can make these corrections? Basically file like a certificate of correction like we do in the US to basically say, this is a translation error and it's a simple fix, or it's not possible to do that?
Well,
York first.
I'll just mention real quickly, this actually came up in litigation. It was something that was caught very far down the road. In the US, there is a procedure for judicial correction of obvious errors in patents. I'm not so sure there is such a thing in Japan.
Nancy?
In China, that could be very challenging. We also have a so-called judicial correction, but that only applies to very limited circumstances. And even during prosecution, if you have a PCT application, you're in a better case. You're able to rely upon the PCT publication. But sometimes you have a Paris Convention application filed in China. It will be very challenging for you to correct mistakes. For instance, in one case, it actually should be, the number should be 1, while the original Chinese attorney somehow wrote 1,000. And technically, it could be an obvious error, but it still cost us multiple rounds of the communications on telephones and written replies to the examiner in order to correct it. Although we hope it's quite obvious that it can be serious.
I see. So obviously every case has its own different value. So you cannot translate every case to the same standard, the gold standard, right? Because I would imagine if I want a really particularly good translation, I would go to a patent translator who has more experience. And if I want to be more specific, I would try to choose the ones where their background is in the same, right? So for a bio case, I would like to go to a bio translator and so on and so forth. So what is a good practice to keep in mind, right? Because you have to balance the cost of translation and to the quality of the translation. So what is a good practice that you guys have dealt with? Lisa or Melanie, I'm sure your clients have something in mind, right?
So I think this also goes to the story that Nancy told. If we are not getting translations to foreign counsel in time for them to really check them and do, that read through that York was talking about before filing, that's an issue. We shouldn't expect them to be able to proofread it correctly if we're sending it at the last minute. So it's up to us as practitioners from the US, if we're sending it over for translation, in order to get it to them in time that they can actually do an adequate job. And then I know Alyssa does, the same thing coming back, and maybe Alyssa can talk to getting the English translations.
Well, actually, I was going to just kind of comment that it's really important to know what your resources are early on. So one way where I see it probably, well, I do lots of translations that are translated to English, and then I proof them in a lot of cases. But one way that it comes up frequently, though, is when you have an application before the patent office and you have a reference and the examiner has included a translation, and it's not a very good translation. So it's really difficult to work with, both to understand what it's disclosing and if it really is pertinent to the case at hand. And so as an example of knowing what your resources are, very often you can get excellent machine translations from the European Patent Office. So that's kind of one thing, to know your resources. It's free. It's a better translation often than what you get out of the US Patent Office. So kind of overarching thought on it.
And a few other comments. I think for patent applications in particular, a professional translation or preparation could be especially challenging when it comes to synonyms, so words with similar meanings. So I remember one case really well. It was a transfer-in case from another Chinese counsel to us. Actually, the invention is about improving the shape of transducer beam. So the beam could be in a tapered shape. So in the embodiments, it actually gives several examples. For instance, it could be like a pyramid, a truncated pyramid, or in a cone. However, actually, when the former Chinese counsel prepared the translation, it translated tapered as cone. So this actually caused a severe problem. In China, we also have the disclosure dedication doctrine. So that means if you give multiple examples in the specification, but you only claim one of those examples, you dedicated the other examples to the public. So basically, in the Chinese application, what we read by the examiner and by the public is that you give examples of cones, truncated pyramids, and pyramids, and while you only claim the cone part, because you translated tapered into cone. So when we were proofreading that Chinese specification, we found this problem and we reported this issue to the US attorney, and she was totally unaware of this. Colon and taper, they could be considered as with similar meaning, but in this case, translating tapered into colon was a severe problem. So I think we can have machine translation, and we can have very experienced third-party translators, but it could be safer, just as some of our larger clients do. They have third-party translation. They ask us to do a proofreading from the technical perspective, a language perspective, and at the same time from our knowledge of the law, to make sure that all the legal doctrines, there are no harm to the Chinese application. I think that's also important.
I agree. Yeah.
That sounds like a big problem there, but I appreciate you pointing out, because I don't think I know that the examples not claim are dedicated to the public. I don't think I've heard that. So thank
It's
you.
a bar to the doctrine of equivalence in China.
Okay. Good to know. Next slide, please. Okay, so I believe we just finished talking about the problem that you may deal with when it comes to professional translation. So the next topic we're going to discuss is keeping the client informed. Next slide, please. So I think the first important thing is who is the client, and we've identified a few of them here. So for U.S. inbound project that's coming in, so your client is the foreign organization, and also I think this is very important to note that the foreign counsel that you're dealing with may not be their in-house counsel. It could be your foreign counsel that they have hired. So it's very important when you go back to the foreign counsel who was handing you the project to ask them to clarify with them who is the client, and then keep the client, the actual client, informed of the progress, so that you're not that you meet your duty to your actual client, right? And for a U.S. outbound project, obviously the client will be the U.S. organization, and then again there too, you want a designated client contact. And for a lot of time, I think if you're dealing with a U.S. organization, you're dealing with their in-house counsel, who may wear different hats. For Colgate, if it's patent matter, you deal with us, the patent people. But there are other organizations out there where they may just have a few attorneys that wears multiple hats. So you just want to make sure you know who to keep in contact with. And then it's very important that you have your initial project reviews, setting up deadlines, setting up milestones, budgets, and all that good stuff. So in terms of keeping the client informed, what we just talked about, right? Sometimes when the project comes in and you get it from a foreign counsel, what are some of the pitfalls that you guys have learned? Elisa?
I'm just thinking the first thing is, especially if you've got another counsel as an intermediary between you and the client, just to be very cognizant of, they may have different expectations. And so to be very clear in the communications with both the foreign counsel and the client. It may be just at the outset or just periodic contact with the client, just making sure that everybody's on the same page as to how you want the representation to go forward, to whether it's, how do you want a draft done? Do you, who do you want it sent to? Just, it's sometimes the smallest things that will trip you up when engaging with a foreign counsel and a foreign client.
And have you seen cases where you haven't really talked to the true client, and it's really just all the communication comes from the foreign counsel, and for some reason they leave the client off? Then what happens when you disagree with the foreign counsel? Do you then try to approach the actual client, or what happens?
Usually not. Usually, I mean, there are many different means that I will use to communicate sometimes. And if I've had difficulty communicating with foreign counsel for whatever reason, I'll insert comments for example, in a draft, so that, the draft will go to the client. The communication, like a cover letter, may not necessarily go to a client, maybe just kind of be filtered through the foreign counsel. So sometimes if there's a very important, I use it carefully, but if there's a very important point that's not being conveyed, or I don't think it's being conveyed, then I'll insert comments into a draft, or ask questions, very careful questions, to try to elicit some greater thought on the other end. So it's tricky, though. It's tricky. However you choose to approach it, it can be very, you don't want to alienate the foreign counsel or the client.
Right. York, any comment on that?
Well, there is a variation on this problem that I've seen in the past. Sometimes, and I'm sure this happens in other countries, the sole criterion of choosing somebody in-house to interact with U.S. counsel is their ability to speak English.
Yeah.
And that person who speaks English may have spent years in the United States having fun at university, and may have a low position in the company, and has a very easy time communicating with U.S. counsel, but a very difficult time communicating with his superiors, and breaking bad news and having hard conversations that you expect are happening because you've communicated to the point person. But that point person may not have the best communication within the company and the client itself. So that has been a challenge in some cases, to realize that sometimes your message isn't getting through, even though you feel like you've been communicating it very well.
That's a good point. So basically, they find someone that's more of a translator that understands what's happening, but the message is not getting passed.
Someone who can't speak frankly with the general manager of the company.
Right. So then I guess another takeaway is to truly understand who your point person is, and if that's enough, or if a matter needs to be elevated.
Yeah, I think the point is, for routine matters, usually you have some comfort, but when you come to the point where you need to have substantive conversations and break some bad news or make some difficult decisions, sometimes you need to make sure you're bringing in the larger group and not just relying on the one person who's designated.
And then I would throw this question to Nancy. So since you're the foreign counsel, so how have your experiences been, right? Since you are the outside counsel to some of your client, and you have to pass through project to U.S. counsel, so how has that been for you?
Some of our Chinese clients, they would request us to keep them, the in-house counsels, in copy in all email communications. But of course, because of the really large number of emails, they wouldn't be able to read every email in time. So whenever we see important updates, important milestones of the case, we would always give them a shout out, maybe even give them a WeChat message or so. However, I do think it is of value for them to keep a copy of all the email communications, because occasionally the in-house counsels could have a minute, and if they are interested in certain details, case details, they could look it up. I think this is quite helpful to satisfy needs of all sides.
Sounds great. Melanie, any additional comments?
No, in my practice, I'm honestly mostly working with foreign counsel in the way that York has described, where we kind of send it to a general email address, and I'm assuming that behind the scenes, any translations that's necessary are getting done. And I had one case where we did get instructions from foreign counsel to file a U.S. national stage application. But I think it was an application that was originated in Europe, and that's why we got the national stage over here. But we had a well-established direct relationship with in-house counsel for this person, this client, and so that was a situation where we needed to clarify, like, should we be reporting, our responses filed back to you, the EP counsel, or do we just, is it really just, this is a pass through? That was one of the few times that I got kind of this roundabout instructions to enter the national stage, not directly from the client. So it is important to determine who you're supposed to be reporting to.
Yeah, so I can speak a little bit to the mystery box. So I think every organization probably has set up, a central patent email box, and we have exactly one person that reviews the incoming and outgoing message. So a lot of the email probably just sits there and doesn't get reviewed, line by line. But I think what Nancy said is fantastic, in the sense that if you could provide a shout out for something that's truly important, so that will stand out in a sea of emails. Because, as you can imagine, this poor little paralegal is sitting in her cubicle reading hundreds and hundreds of emails a day coming from all over the world. And she's not going to be able to identify what's more important and what's not important. So, but when I know for a fact that when an outside counsel writes even in the subject line, right, urgent or due date or response needed, and what's even better is if you can put down, response needed by a certain date, then that would definitely call out to her, and then she will pull those on first. And then if she needs to reach one of the attorneys here, she can then forward that to us. Otherwise, it could be days before she come across an important email, and sometimes the response time may have already passed, and you're not going to get the client instruction. And what would be even worse is if the outside counsel then come back to you with a reminder. Have you read my email from 3 days ago? That would not be a good scenario.
Mm-hmm.
Summary is definitely appreciated. So I think we got this covered, keeping the client informed. So can we go to the next slide, please? Okay, so this goes back to what we talked about before regarding the language barriers. And I think one of the key points to remember is written communication. So in terms of email, something that's the best. Number one, you have documented proof and you've already made the communication. And also for the in-house attorney that may be too busy, maybe they have some time later to come back to that, right? They'll be able to read it. And then I see for the language barrier, we have a comment on here. Sometimes if you're doing oral communication, maybe you want to hire an interpreter if it's something truly important and you want to make sure your client, who may not be fluent in English, truly understand what you're saying. So you may want to get an interpreter. But I have to say, I don't think in my years of practice we've ever had an interpreter on either side, either within the company or outside the company. We've never done that before. And then if you are using an interpreter, then it's best if you use the same ones. Keep it to the minimum. For a couple of reasons. One, if you use the same ones, you can basically build up their vocabulary so that they have a working knowledge of most of your dealings, right? And number two, which we're going to touch upon later, about attorney-client privilege. Then you can instruct your interpreter, your special interpreter, how to preserve attorney-client privilege, and this is for the U.S. So coming back to the interpreter, and like I said, I've never worked in a situation where an interpreter was needed. I was wondering if any of the panelists has any experience working with an interpreter, and what was the occasion that arose that required you guys to call in an interpreter?
I've had not a professional interpreter, but where I've had to reach out to somebody who speaks the language. In this case, it was Korean, because I really had to kind of get into some issues and really understand some nuance of it was preparing a petition, and there was some declarations that were associated with it. And so you want to be very careful, of course, that you accurately describe a situation. And again, it was an in-house, fortunately, within our firm. But that was a clear situation where we had to have an interpreter to get to those the finer points.
Okay. Anyone else had to work with an interpreter on patent cases?
I have. I'll just comment very quickly. And again, it was to facilitate communications between the U.S. in-house counsel and Japanese attorneys in developing briefing and to deal with some of the very fine points of the technology that they wanted to be able to communicate precisely. And we found it was just easier it was a video conference, and to pull, it doesn't matter where the interpreter's at, anywhere in the world, they can jump on the video conference. And instantly the communications just improved 100%. And the meetings were much more productive. It was well worth every penny that was spent.
That's great. But it's also great that you found out early so that you don't have an issue later on.
I think in patents, it becomes very clear very early on where you need professional translations, and whether it be something you send out and have returned, or whether it's something that you need a live person, and whether that needs to be a professional translator versus somebody who's just very fluent in both languages. So fortunately, it's I think a little bit easier in the patent world.
That's true. That's true. I think we're running out of time, so let's go to the next slide. Hopefully we have a few minutes on the section. So actually, let's go to the next one. So this is the very last topic that we wanted to touch upon today, which is attorney-client privilege concerns when dealing with foreign counsel. And again, this is more US-centric. So a lot of these may not apply outside of the United States. We apologize for that. So next slide, please. So I think the first thing we want to talk about is the rules, at least for practice before the U.S. Patent Office. And I think, Melanie, you can speak better to this than I can. So why don't you give it a go?
Sure. So yeah, this portion is very U.S. centric and dealing with the U.S. attorney-client privilege, and for proceedings before the Patent Office, there is a specific rule that covers this. It's a very generous rule. It covers not only U.S. practitioners, but also U.S. patent agents and foreign jurisdiction patent practitioners. And the latter two categories are covered as long as they're doing anything that's necessary and incident to the scope of that practitioner's authority. And the key here is that they can do this even if they're not being instructed by a U.S. attorney. So if you have sometimes you have an in-house counsel, actually not you can have somebody may hire a patent agent and that's their main person that's doing work for them at the Patent Office. And even if they're not being supervised by a U.S. attorney, the work that they do with the Patent Office would be covered by attorney-client privilege for proceedings like IPRs at the Patent Office. But if we go to the next, and it does treat the attorneys and agents the same, whether they're foreign or U.S. But if we go to the next slide, this is an example. You have to be kind of careful because the scope is limited to basically application preparation and prosecution. So when you start doing activities, and sometimes there's a blurring of lines, when you're doing licensing and contract and invalidity opinions and assessments, before that aren't related to the application, you can get into trouble if you are in-house counsel working directly with a patent agent in the US or even in a foreign jurisdiction. So you just have to kind of know be aware of that. And I guess that, as attorneys, it's our duty to help our clients understand, when their communications might not be protected in U.S. discovery. And as York was saying, discovery in the U.S. is just so much different than in foreign countries, that I think you can catch them a little off guard. They might be a little foreign clients might be a little bit surprised at what is discoverable in the U.S.
I think that also goes back to, right, why there are certain times, right, when we will craft email in almost a ambiguous way because you want to soften the language, right? You can't be completely honest in your assessment. For example, you might want to say something about, I don't believe these claims are patentable over the D1 and D2, but here are the arguments I want to make. Sometimes you wish you can be that honest, but you cannot because of discovery rules, right? I remember being taught, never put down in writing what you don't want other people to read.
Yeah.
So I think that's something that you have to be very cognizant of, and that may tie to some of the reasons why the language sometimes gets softened.
It is. So skipping ahead a little bit, the patent office is great. You got a lot of coverage there, but once you go into the federal courts and the state courts, it's all over the map. Like it really is jurisdiction dependent. There's some jurisdictions that we call non-choice of law. If the communications are not between a U.S. attorney and the client, and that's it, like it's not covered. So it doesn't matter if it's a foreign, Nancy talking with a Chinese client, that stuff in those states, all of it would be discoverable, which is like crazy, right? But luckily that's the outlier case, and there are situations, there's a couple tests. We have the touch-based test, which, the US courts will recognize a foreign privilege, depending on if that jurisdiction has, the activities are more important to that foreign jurisdiction. They will recognize the foreign law if it exists, but it doesn't always exist. And again, it can go back to who is doing the communications. Are they an actual attorney barred in that foreign country, or is it an agent? And a lot of EP attorneys and Australian attorneys, we say attorneys, but the foreign counsel is actually a patent agent, which under the PTO rule would be covered, but it depends on whether those agents have a duty of confidentiality in that country. So it gets very fact specific. And so that's the fallback rule, like Judy said, is pretty much you just have to figure it's out there. You have to write it as if there's no privilege, because you might end up in a jurisdiction that wouldn't consider that communication privileged.
And on that note, I think we're out of time. So if there's anyone on the call that has any questions, maybe we can stay on for an extra 5 minutes if the panelists are available. And if not, we thank you for your participation today.
Yeah, I don't see any questions. So
Okay, great, fantastic. Then thank you all. Thank you to panelists, especially Nancy. I think it's way past the bedtime.
yeah.
We'll see you guys.
Pleasure.
Thanks, Judy.
Thank you.
Thank you all.
Thank you.